Good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, November 20th, 2024. The time is 9:34 a.m. With us today are Commissioners Bobby Janeka and our General Counsel, Mary Smith. Commissioner Gonzalez is going to join us, we hope, shortly virtually. Registration, and I'm John Neerman. Registration is now closed, but if you'd like to address the commission on a particular item, please visit our registration table or email agenda@tceq.texas.gov. Please include your name, your affiliation, and identify the item that you'd like to speak to, and we will do our best to accommodate that request. For those who are addressing the commission, our general counsel or I will inform you of your time limits and when it's your turn to speak. I want to thank everyone for being present today. Ms. Smith, we're going to defer item 1 until after item 3. So if you'll please go ahead and call item 2, the motions to overturn.
Item number 2 is the consideration of the motions to overturn the executive director's issuance of air quality standard permit number 175198 to North Texas Natural Select Materials, LLC. As a courtesy to legislators and statewide elected officials, the commission allows officials to address the commission. As a reminder, the commission may only consider the record, including the parties' filings and arguments, the draft permit application, and the ED's response to comment when making its decision today. We do have Representative Reggie Smith here to address the commission, and we will take his comments first. After Representative Smith, the order for parties will be the movants, followed by the applicant, the ED, and OPIC. The movants will have 8 minutes of oral argument time collectively. The applicant will have 8 minutes, and the ED and OPIC will each have 5 minutes. And the movants may save time for rebuttal as they bear the burden of proof.
Thank you, Representative. We're ready for you. And I'll ask you to check the mic at the podium and make sure you have a green light there. Not yet. There we go.
Yeah.
Good morning, sir.
Yes, sir. Good morning, and thank you, Chairman, Commissioner, Council, and staff. Thank you so much for your warm welcome this morning. I appreciate it. I understand that we're speaking on item number 2. And
item 2, correct.
The rock crusher.
Motions to overturn.
Yeah. Okay.
Yes, sir.
And that's in connection with that rock crusher. You know, my understanding is you have 4 motions to overturn here this morning, and I think I have some understanding of what those are about. What I wanted to do is just make a statement and then let you get about your business. But thank you for your time. As you may or may not know, I'm proud to represent House District 62, which is Grayson, Fannin, Franklin, and Delta counties. Denison, Texas is certainly in Grayson County. And I stand before you today to voice my strong opposition to the proposal for the permanent rock crusher in that community, and in our community as a whole. This issue is not just about zoning or land use, it's about the health, safety, and well-being of our residents. Firstly, I want to highlight the environmental concerns associated with the operation of a rock crusher. The dust and emissions generated by such machinery pose a significant threat to our air quality. Our community has worked hard for years to maintain a clean environment, and we cannot allow a permanent installation that would undermine those efforts. Clean air is not just a luxury, it's a necessity for the health of our families, our children, and our elderly citizens, of which we have many. Moreover, there are legitimate health risks tied to increased particulate matter and noise pollution that come with rock crushing operations. Vulnerable populations, including those with respiratory issues and other pre-existing health conditions, could face exacerbated health problems. As a representative, it is my duty to protect my constituents, and I cannot stand by while their health is put at risk. I have heard from countless residents, and I have, who are deeply concerned about this proposal. Many have expressed their fears regarding the adverse effects on property values and the local economy. A permanent rock crusher could deter potential homeowners and businesses from investing in our community, leading to a decline in economic growth. Denison, in particular, deserves a future that is vibrant and prosperous, not one that is overshadowed by industrial operations of this kind that harm our quality of life. Furthermore, I urge you to consider our local zoning regulations and land use plans. The establishment of a permanent rock crusher in Denison does not align with the vision that we have for our community. We have taken steps to ensure that our land is used responsibly, and I implore you to honor those efforts. In closing, I kindly request that the TCEQ prioritize the voices of the Denison community. I urge you to vote favorable on the motion to overturn the executive director's approval for this project. Denison is a community that values its health, its environment, and its future. Let's work together to protect those things. And let me just add that this particular rock crusher, while I understand batch plants and those things are a necessity in a growing state like what we have, okay? This particular rock crusher could not be put in a nicer area of Grayson County. It's flowing hills and pastures and beautiful homes. And I might add that there is no way, in my estimation, after having spent some time out there, that this thing is anywhere near 440 yards away from the nearest residence. I would say that the motions to overturn in connection with the notice provisions, I think that's something you should take seriously, because we're talking about the placement of this item. Any movement of it all could impact that rule and come into direct violation of it. There are homes everywhere, beautiful homes. And so I would just say, keep in mind what's going on out there with the notice provision and whether or not we've really complied with the law. Keep in mind what's really going to happen with the value of those beautiful homes once this thing is out there. Keep in mind that Grayson County has $40 billion, yes with a B, dollars worth of development in connection with Texas Instruments and Global Wafers that are going in right now, that we're going to be a chip hub for North America. And we're going to have growth of all kinds, and economic growth is part of it. And this thing is going to be sitting out in some of the most beautiful real estate in Grayson County. It will have a direct impact, not only in just property values, but as I've mentioned, on the environment and on the air and on the water, for what is going to be a wonderful economic center for Texas. But thank you.
Thank you, Representative Smith. Appreciate you being here today, and we certainly appreciate your service to the state.
Yes, sir. Thank
you.
Yours too.
Representing one of the movements, I believe we have Mr. Smith.
Good morning, sir.
Good morning, Chairman and Commissioners. And I believe we are the only movement today, so I'm planning to use the 8 minutes. So I represent Mr. John Huckle in this matter. Mr. Huckle is the owner of the residence at 4778 Fannin Road, which has previously been determined to be within 440 yards of the proposed crusher. And Mr. Huckle is asking the commissioners to overturn the executive director's decision approving this permit for reasons of air quality and the location of the crusher. And in the alternative is asking the commissioners to vacate the decision of the executive director, remand it for re-noticing the application and reopening the public comment period in order to consider this new location of the crusher that was disclosed at best at the on the last day of the public comment period at the public meeting, and perhaps was actually disclosed 3 months following the close of public comment. So I'd like to get into that timeline. 2 days before public comment closed, in the regional office of the TCEQ up in Dallas-Fort Worth determined that the rock crusher was within 440 yards of 4778 Fannin Road. And the next day, NTNSM sent TCEQ updated maps showing a new location to the south of where the crusher had previously been proposed to be, and indicated that these maps would be available at the public meeting. However, my client, Mr. John Huckle, was at the meeting and does not recall these maps being presented or the new location being discussed. And so even if the maps were presented, that would not give the public enough time to consider and assess this new location of the crusher. Now let's fast forward. We've gone through the motions to overturn, or most of that process. We've heard about updated representations regarding the location of the crusher, but not heard exactly where it is. And then the day before replies are due, we actually get those, John Huckle gets those maps with the new location of the crusher. And again, that was 3 months after the close of public comment. And so why does this matter? What would the public do in a public comment period? Well, as Representative Smith mentioned, there's significant concern that this is still within 440 yards of a residence. We are not entirely certain the measurement methods that TCEQ has used or NTNSM has used. However, it appears that they may be using lat-long coordinates. If that's the case, we need to be able to assess that those coordinates are in fact accurate, that they accurately represent where these residences are and the edges of these residences. Now that the crushers moved to the south, it's possible that it could be encroaching on the 200-foot property line. And the sliver of land that may be available for this crusher has just become so small that it's not clear that the crusher would actually fit within that sliver. So those are just some examples of things that the public would like the time to be able to consider and assess in a reopened public comment period. And then I'd like to just briefly touch on the air quality issues. The air quality standards for PM 2.5 and quartz silica have both been lowered. The threshold amounts for both of those have been lowered since the protectiveness review for the rock crusher standard permit was conducted and concluded in 2008. And so the standard permit is no longer protective of human health and the environment, and ensuring that this crusher would be as well. And then also this particular application has about 6 acres of stockpiles proposed, and that's significantly more than was tested for in the protectiveness review. And so I will save the rest of my time for rebuttal, and happy to answer any questions that y'all might have. Thank you.
Thank you, Mr. Smith. I have no questions. Colleagues, any questions? Seeing none. Thank you, sir.
Next, we would call the applicant forward, but I understand nobody has signed in for the applicant.
Is there anyone present for the applicant? All right, let's move on.
Okay, then we'll go to the ED.
Good morning.
Good morning. Good morning, Commissioners, General Counsel, and Public Interest Counsel. My name is Elizabeth Black with the Environmental Law Division, representing the Executive Director. With me is Kristen Jaker from the Air Permits Division and Archer Tate from the Dallas-Fort Worth Regional Office by webinar to answer any questions. For the reasons discussed here and in the ED's response brief, the Commission should deny the motions to overturn the ED's decision to issue North Texas Natural Select's Air Quality Permit number 175198. The ED properly reviewed the permit application and determined that it met all applicable state and federal rules and regulations. First, North Texas Natural Select Materials follows all setback requirements of the Air Quality Standard Permit for permanent rock and concrete crushers. Move-ins argue that the ED erred in issuing the permit because the public was not made aware of NTNSM's updated representations. The applicant provided updated representations at the public meeting held on August 1st, 2024, where they were made available to the public during informal and formal comment period. These updated representations were then verified by the Dallas-Fort Worth Regional Office on August 7th, 2024. Finally, after the permit was issued on September 4th, 2024, the entire permit packet, including the updated representations, was made available to the public on TCEQ's online record search. Secondly, movants argue that this permit registration does not comply with NACs for PM 2.5 and PM 10. The ED conducted an extensive protectiveness review during the development of the rock and concrete crusher standard permit, designed to comply with the applicable NACs at the time the standard permit was issued, which was July 30th, 2008. This permit registration is designed to comply with the NACs in place at the time of permit issuance. Therefore, emissions of PM 2.5 and PM 10 from this registration should not cause or contribute to an exceedance of the NACs and are protective of human health and the environment. Movants also argue that silica emissions from this plant exceed TCEQ's health-based screening values. However, adverse impacts to human health or welfare as a result of silica emissions are not expected from this proposed permit. Based on these arguments and those noted in the ED's response brief, the ED again asked the commissioners to deny all motions to overturn the ED's decision to issue NTNSM's permit number 175198. Thank you.
Thank you, Ms. Black. Colleagues, any questions for Ms. Black? Seeing none.
OPIC.
Good morning, Mr. Martinez.
Good morning, Chairman, Commissioners, General Counsel, and Executive Director. My name is Eli Martinez with the Office of Public Interest Counsel for the record. We've reviewed the motions to overturn and replies filed by movements in this matter, and consistent with our briefing, we cannot find that the Executive Director clearly erred in evaluating the application for this standard permit, utilizing the protectiveness review in place at the time the application was submitted, because protection of health, analysis of cumulative impacts for concrete operations of the type and throughput authorized under this type of registration, analysis of background concentrations and back requirements were analyzed and approved by the Commission in the development and approval of the standard permit applicable to this registration. The ED is charged with applying those requirements to applicants and cannot be said to have erred by doing so in the absence of a change to the standard permit itself. We do recognize that the EPA has made updates to the NACs since the protectiveness review was conducted, and OPIC remains of the opinion that the standard permit may benefit from the Commission re-evaluation of the standard permit to ensure that it is protective and in compliance with the recently updated NACs. Further, OPIC cannot recommend that the requested relief be granted based upon roads and zoning issues, which the Commission has no jurisdiction over, nor contentions that the facility will be continuously operated, which is not allowed under Section 3H of the operational requirements of the standard permit, which stipulate that a rock crusher and associated facilities cannot operate outside of daylight hours between 1 hour after official sunset and 1 hour before official sunrise. The issue raised in the movements reply is related to the timing in which the public was made aware of the updated location of the facility made in the application materials is concerning, because we believe that potentially impacted residents should have the opportunity to determine and comment upon whether the distances between the facility and nearby residences are correct, complete, accurate, and in satisfaction with the buffer requirements provided by law. However, we are also aware of the fact that there are practical constraints to the timing of the RTC, and that the issue of location had already been raised and considered by the Executive Director, and the DFW Regional Office confirmed that the previously identified residence is now outside of the 440-yard buffer zone. We therefore cannot find that the ED erred in her disposition of this issue and must recommend that the MTO request be denied. Thank you. We're available for any questions.
Thank you, Mr. Martinez. Colleagues, any questions? Seeing none. Mr. Smith, you have 2 minutes and 50 seconds for rebuttal.
All right, thank you. So one point I'd like to make is that when the application is filed, the applicant represents that it is, complying with all the permit requirements, and then the public gets to come forward and challenge that. And so we're essentially back in that same position that we were when the application was filed. We've had a new location disclosed, and the public has not had the chance to evaluate that, assess that, and come to an open meeting and voice those concerns and assessments that it has made. We still think it's unlikely that the maps were actually presented at the meeting. I just heard from the incoming county commissioner for Grayson County, who also says that he does not recall these updated maps being there or being discussed. And the air quality issues are, they're essentially ones with the standard permit here. Once the EPA revises its air quality standards, then the TCEQ is obligated to update its standards to comply with those. And so since we're dealing with standards from back in 2008, this rock crusher is certainly not guaranteed to comply with the current NAAQS, as well as TCEQ's own regulations. And one more point is that even if the maps were disclosed at the public meeting, that's simply not enough time for the public to make these assessments, go out, make its own determinations and measurements. So I appreciate y'all's consideration and happy to answer any questions if they have arisen in the meantime.
Thank you, Mr. Smith. Colleagues, any questions? Seeing none. All right, colleagues, I think we do have a notice issue on this with respect to the facility location. I would overturn this authorization and allow the public an opportunity to comment on the revised representations concerning the facility location.
I entirely agree.
I also
Commissioner
agree.
Gonzalez,
I'm in agreement.
You appear to be muted.
we can't hear you.
It's showing unmuted on mine.
All right, well, we're having some technical difficulties with Commissioner Gonzalez. Do you want to offer a motion?
I would. I move that we overturn the executive director's issuance of air quality standard permit number 175198 to North Texas Natural Select Materials LLC and remand the matter to the executive director to renotice and provide for opportunity for public comment on the revised permit application.
I second. The motion has been made and seconded. All those in favor say aye. Aye. The motion carries. Ms. Smith, when you're ready, I'll ask you to please call item 3.
So item number 3 is the consideration of the application by Treasure Island Laguna Azure LLC for new Texas, for new TIPD's permit number WQ00160920001. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record. Again, as a courtesy to legislators and statewide elected officials, the commission allows officials to address the commission at its agenda meetings. As a reminder, the commission may only consider the administrative record, including the parties filing the draft permit, the application, and the ED's response to comment when making their decision today. And with that, we have again Representative Smith here.
And Representative, good morning. You started as a novice and you're going to be an expert walking out of here. Representative, we're going to double check your mic. I'm not sure if we're picking you up or not.
Not a professional on that. Yeah, no, I appreciate you all and thank you, Chairman, Commissioner. I failed to recognize Chairman Gonzalez. Thank you so much for your service and your time today. I wanted to take a moment and address this application for the Treasure Island Laguna. As I stated earlier, I represent House District 62, which is Grayson, Fannin, Delta, and Franklin counties up in North Texas. And this particular project would be right outside of Van Alstyne, Texas, in the southern part of Grayson County. As a matter of context, Grayson County, as was mentioned earlier, is going to be the home to, it is currently developing what is going to be the largest corporate investment in Texas history, with Texas Instruments putting in a $30 billion facility and Global Wafers putting in roughly a $10 billion facility, and then all the incumbent industry and development that will come around that in the coming years. Suffice it to say that my little home county is turning into something quite different than what I grew up in. But that is the way it's going. Texas is growing, and it's a beautiful thing. However, we have to manage this growth, and this particular project is evidence of the need for management that I speak of. Numerous constituents have reached out to me in my office over the past several months, voicing their concerns with the project relating to this permit application. The current and future growth of Grayson County requires much care and consideration in the planning process to ensure that each project is efficiently and effectively completed. From the start of this project, I, along with other local leaders, have felt that the current plan, including the creation of a wastewater facility, is not in the best interest of the surrounding communities. I think in your application, you will notice that there is some 1.4 million gallons of what will effectively be sewage that will be dropped off into a waterway, a creek that runs right down through the southern part of Grayson County, excuse me, outside of Van Alstyne, and right behind a myriad of homes and farms and other lush areas, just like the rock crusher is situated in a lush area up in Denison. We believe that the 1.4 million gallons or whatever it is that's estimated there will absolutely cause flooding in those areas. I don't think there's any question. That will be what happens. And there are homes up and down that creek. Something that I really want you to consider because granting this application will cause damage to those folks. And not only that, but it will cause damage to the environment in our area. Having that kind of sludge, however you treat it, running through one of our waterways and on its way down to Collin County and surrounding areas. And we just think that that's unacceptable. If this project comes to fruition, the community that this wastewater treatment facility will serve will have a population greater than Van Alstyne. A population of that size will ultimately result in the residents of the planned community affecting the resources of Van Alstyne while not contributing tax dollars for things such as wear and tear on city roads. The topic of vital water resources is also something that is concerned when discussing the future of the Treasure Island Laguna Azure permit request. The community, along with a wastewater treatment facility, will tap into the city of Van Alstyne's water aquifer. This could quite literally drain a valuable resource for the residents of the city. Along with the concerns raised by the city, the Van Alstyne Independent School District has also expressed concern concerning the construction of a community that this wastewater treatment facility is planned for. The estimated 12,000 residents to the area will severely strain the resources of VAISD. The additional 4,000 proposed homes would require at least 2 additional elementary schools and 1 junior high school. We simply do not have the resources in place for a project of that size. I would like to note that both the city of Van Alstyne and Van Alstyne ISD also oppose the plan as it currently is. To echo my previous statement, while we will support and welcome growth to the county, we must do this with care and by making the best choices for current and future residents. Rather than going forward with the current project, including this application, I feel that it is in the best interest of our community to pause this project, and I encourage our friends at Treasure Island Laguna Azure to work with the city of Van Alstyne and VAISD to come up with a plan that addresses the concerns raised. Thank you.
Representative, again, thank you for being here this morning. We appreciate your comments and thank you again for your service to the state.
Yes, sir. Appreciate it.
Thank you.
Uh-huh.
Colleagues, we have a few requests on this item. I would deny the individual hearing request. Ms. Arsenal and Mr. Dubois simply live too far from the proposed facility to be affected in a manner different from the general public. The Watsons failed to raise relevant and material issues in their comments, which is a statutory requirement. So again, we need to deny those requests. I would grant the city's request. The city is entitled to a hearing. The proposed facility is within the city's ETJ. The city identified relevant and material issues, namely regionalization and water quality, and that includes the protection of drinking water. Those concerns are squarely within the city's statutory authority. So I would refer the city's request to SOA on those two issues. As for the request for reconsideration, they raise issues that are either outside our jurisdiction or were already responded to in the response to comments. That's how I come down. Commissioner Janeka.
I appreciate that thorough description, and I'm in agreement. I would support the referral of the city with those issues and denial of the other requesters.
All right, thank you. Commissioner Gonzalez, or have you been able to join us?
Can you hear me?
Yes, wonderful.
Okay, great. Yeah, I'm glad they worked out the IT issues. I'm in agreement as well.
All right, I think we're ready for a motion then.
I move that we grant the hearing request of the city of Van Alstyne, deny all remaining hearing requests and requests for reconsideration, refer the application to SOA for a contested case hearing on the following issues: whether the draft permit is protective of water quality, including the protection of drinking water, in accordance with applicable regulations, including the 30 Texas Administrative Code, Chapter 307, Texas Surface Water Quality Standards, and B, whether the draft permit complies with the Commission's regionalization policy pursuant to Texas Water Code Section 26.081, and that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries.
Chair, just for a second there, for the record, I was voting with my colleagues on the previous item.
Thank you, Commissioner. Appreciate
Thank you.
that. Ms. Smith, when you're ready, please call the first item. I guess we'll call it item 1.
Yes, we'll give everybody a chance to get up to the table. Then I'll call it. Item number 1 is the consideration of the proposal for decision and proposed order concerning the petition, excuse me, for the creation of Schenkel Road Municipal Utility District of Ellis County. The parties have been notified that the petitioner, protestants collectively, the ED and OPIC will each have 5 minutes of oral argument time. The petitioner should speak first and may reserve a portion of his time for rebuttal as the petitioner bears the burden of proof in this matter. I believe we have Mr. Steven Selinger here on behalf of the petitioner. Oh, sorry, thanks.
Good
It
morning.
looks like the mic is still on. Good morning, Chairman and Commissioners. My name is Natalie Scott, and I do represent the applicant here, Mr. Steve Selinger, for creation of the Schenkel Road Municipal Utility District. And we're here to request that you overturn the PFD on the basis that it fails to comply with the law as prescribed under Texas Water Code 54.021. Successful mud creation requires that under that provision of the water code, that there be a finding that the mud is feasible, practicable, necessary, and a benefit to the land to be included in the district. Those findings were made under the PFD. There are considerations that you may take into account when making those findings, but they are not a standalone reason for denial of the mud creation. And in this case, the stated reason for the denial in the PFD for the mud's creation was that construction costs were unreasonable. Now, I will submit to you that construction costs are what they are. And construction costs are estimated, the best estimate available at the time that the petition is filed. And that was what was submitted at the time that the application was filed. And that was 4 years ago. In that lapse of time, once the hearing comes around, then of course the protestants are able to put up expert testimony that to poke holes in what was originally estimated at the time of filing. But it's my understanding that the granting or denial of the petition is to be decided at the time of filing. Now, even as we stand here today, based on what the PFD's reasoning is, there have been changes for my client that are not in the record that relate to East Garrett Water Supply Corporation's tacit agreement to provide water and additional bids on the wastewater treatment facility. And that puts a very big burden on staff if they don't know when the evaluation is to be made, because if we're reevaluating based on the protestants' testimony and then we're reevaluating today based on a change in circumstance, that does not put an end in sight for them. And I think it's a tremendous burden on the staff. And for those reasons, I support the overturn of the PFD and the granting of the district, and I'll reserve the remainder of my time.
Thank you, Ms. Scott.
Thank you.
And next for the protestants, I believe we have, we'll call the protestants next. It's Mr. Altman.
Good morning. I'm Eric Allman for Citizens Against Ellis County Mud. Stephanie Albright for Ellis County will speak after me. Again, Eric Allman here representing Citizens Against Ellis County Muds. Good morning, Chairman, Commissioners, General Counsel, Public Interest Counsel. I will address the availability of comparable service, except I will quickly note that the issue of cost in this case is not one of timing. It's one of glaring omissions at the time of the submission. So that's not the issue here before you. Now, the applicant has failed to show that East Garrett Water Supply Corporation is not able or willing to provide comparable water service. Since comparable water service is available from East Garrett, the MUD is not necessary, warranting denial of the application. That reason alone renders this unnecessary. The ALJ finds water from East Garrett is not available primarily because no final agreement for water service has been reached. This wrongly places the burden of proof on protestants to demonstrate that water is available rather than correctly placing the burden of proof on the applicant to say water is not available. Furthermore, this rewards an applicant's refusal to engage in good faith negotiations with the water service provider. There's no evidence that East Garrett is trying to apply unreasonable conditions upon the provision of water service. If a final binding contract is needed to show availability, then any applicant can circumvent this requirement simply by refusing to engage in good faith negotiations. Now, also, the approach places you at risk of having inconsistent findings. In a few weeks, you'll take up a wastewater permit application for the same development from the same applicant. Here, it's the applicant's advantage to say water is not available from East Garrett, so they can show this is necessary. In that case, it's to the applicant's advantage to say water is available from East Garrett, so they don't have to deal with the contaminants present in the groundwater. If in each case you give the applicant the benefit of the doubt, you risk issuing this authorization based on one assumption for East Garrett, and in a few weeks issuing that authorization based on the opposite assumption. That type of administrative amnesia is something that you should avoid. And for those reasons, we ask that the proposal for decision be upheld for the reasons of unreasonable construction costs and also the additional reasons I have addressed. Thank you.
Thank you, Mr. Allman.
Good morning, Commissioners. My name is Stephanie Albright. I am with Bickerstaff, Heath, Delgado, Acosta, and I represent Ellis County in this matter. First, Judge Todd Little, the County Judge of Ellis County, was planning to be here today but couldn't make it, but wanted to ask that I relay his comments that he hoped that you would uphold the PFD and deny the MUD. So the applicant in this matter has not demonstrated that the proposed MUD and the subsequent development is legally, financially, or technically feasible. The county understands that in a petition that costs can be estimated and that a proposed development can change and be adjusted over time, but that's not what's happening in this situation. The developer has presented costs that are underestimated by nearly $22 million in the application. Major dollar components of the system are omitted from the cost estimate in the application, including groundwater wells, over 18 groundwater wells, and a wastewater treatment plan. This gross underestimation of costs, and it's combined with an overestimation of lots on the property, supported the ALJ's conclusion that the applicant did not meet its burden under the Texas Water Code. Additionally, the applicant has proposed a fictional plan for development that cannot actually be implemented. The applicant proposes to supply water to the proposed development using 18 domestic groundwater wells whose locations are not presented in the application. Setting aside the fact that this arrangement would be in violation of the Prairie Land Groundwater Conservation District rules regarding public water systems, as well as spacing and pumping limitations, the applicant did not demonstrate that this proposal can meet TCQ's public water supply requirements. The MUD is not legally feasible for this reason, and the applicant has not met its burden. Authorizing the creation of a district when the applicant so egregiously disregards the requirements of Chapter 54 of the Texas Water Code begs the question, what is the point of reviewing these petitions in the first place? Even though costs may be projected and development plans can change, the applicant is required to show at the time of the application that the property can feasibly support a development at the time of the petition. The applicant here is not simply asking to draw boundary lines. The applicant is asking to create a new local government entity, and it will have the power to levy taxes, to fine its residents, to issue debt, and to condemn property. To be granted the privilege to create a MUD in the state of Texas, an applicant should at the very least provide a plan of development and projected costs at the time of the application that demonstrates that the proposed project is actually feasible. The applicant in this situation has not done so. For these reasons, and all of the reasons that the county provided in its closing arguments, Ellis County urges the commissions to accept the PFD and deny the petition to create Shankle Road MUD. Thank you.
Thank you, Ms. Albright.
We have, sorry. Okay.
Executive Director.
Oh, I'm sorry. ED, sorry.
Good morning.
One of those mornings, sorry.
Good morning, Chairman, Commissioners, General Counsel, Office of Public Interest Counsel. My name is Kayla Murray, and I'm an attorney in the Environmental Law Division representing the Executive Director. With me today is Justin Tack, Manager of the District Section. The Executive Director respectfully recommends that the Commission issue the Shankle Road MUD order as drafted by the Executive Director and create the district. The petition is in compliance with all applicable statutory and regulatory requirements. The ED recommends that the Commissioners reject the proposals of the ALJs and their proposal for decision and create Shankle Road MUD. Pursuant to Texas Water Code Section 54021A, the Commission shall consider the following factors when determining if a MUD should be created: the availability of comparable service, the reasonableness of projected construction costs, tax rates, water and sewer rates, and lastly, whether the district will have an unreasonable effect on the following: land elevation, subsidence, groundwater levels, recharge capability of a groundwater source, natural runoff rates and drainage, water quality, and total tax assessments on all land located within the district. The ALJs concluded that the applicant did not meet the requirement of the reasonableness of projected construction costs and tax rates. As stated in the ED's closing argument, the applicant's projected costs are reasonable when compared to other taxing authorities in the area. It is also well established that the reasonableness of the projected costs and rates are determined at the time of the petition. The ED found these costs contained in the preliminary engineering report to be reasonable. In their PFD, the ALJ stated that they gave the ED witnesses testimony little weight when he stated that the applicant's estimated costs appear to be reasonable. The ALJs did, however, give great weight to Ellis County's expert, stating that his superior experience resulted in more reliable estimates than those provided by the applicant's expert. Experts will disagree on many things, including construction cost estimates. There is no Texas Water Code statute or TCQ rule that provides a standard or benchmark for reasonableness of estimated construction costs. Staff's longstanding practice is to compare the applicant's cost estimate to similar projects in the area to make a reasonableness determination. That is exactly what was done here. As noted by the Commission regarding this issue and other recent mud creation cases, the discrepancy between the estimated costs by the applicant and the protestant does not render the applicant's construction costs unreasonable. It is the ED's determination that the applicant has met his burden of proof on the factors set out in Texas Water Code Section 54021, and as such, the ED recommends that the Commission grant the creation of Schenkel Road Mud of Ellis County. Thank you, and we are available for questions.
Thank you, Ms. Murray. Any questions, colleagues? Seeing none.
Now we could go to OPIC.
Good morning.
Good morning. Chairman, Commissioners, Executive Directors, Attorney, and staff. For the record, I'm Jessica Anderson with the Office of Public Interest Counsel. We participated in the hearing, evaluated the evidence and arguments presented, and concluded that, in accordance with the ALJ's proposal for decision, applicant has not shown that the projected costs for the development are reasonable. Because applicant has not shown the district's creation can meet all applicable requirements, OPIC agrees with the ALJ's recommendation that the Commission should deny applicant's petition for creation of the district. In determining whether the project is feasible, practicable, and necessary, and whether it would be a benefit to the land included in the district, the Commission must consider the reasonableness of projected construction costs, tax rates, and water and sewer rates. Applicant failed to present evidence showing how its estimated costs were calculated, nor why they believe them to be reasonable. This is demonstrated by applicant's failure to include any construction bids or references to such bids in the evidence. Additionally, applicant did not provide any evidence comparing its cost estimates to similar developments in order to demonstrate reasonableness. Further, while the ED's witness concluded that the costs were reasonable, no independent investigation was conducted into the estimates. Rather, the ED's witness relied upon the applicant's assertion of reasonableness. Additionally, protestants' witnesses raised concerns about applicants' underestimation of the costs associated with the water and wastewater systems, as applicant failed to include in its preliminary engineering report the cost for groundwater wells or a wastewater treatment plant. Protestants also raised concerns about applicants' failure to account for essential components of the systems, as well as its underestimate of discharge volume. Further, protestants discussed issues concerning applicants' potential overestimation of the number of residential lots that could be built within the district, as applicant's witness acknowledged that he did not consider any land use restrictions in prairie land GCDs and the Commission's rules. For these reasons, OPIC agrees with the ALJ's conclusion that the applicant has not shown that the projected costs for the development are reasonable. Because applicant has not demonstrated the reasonableness of the projected cost, we recommend that the Commission adopt the ALJ's proposal for decision and deny this petition for creation of Schenkel Road Municipal Utility District of Ellis County. Thank you, and we are available for any questions you may have.
Thank you. Colleagues, any questions? All right, Ms. Scott. We have 2 minutes of rebuttal time.
Oh, there we go. I think that this is an issue that has been before you in the past. And with regard to the cost issue, as I stated before, cost is only a consideration in the findings that are required to grant the petition. And those are reasonableness, feasibility, practicability, and a benefit to the land to be included in the district. Those findings have been made in the PFD. So the difference in cost estimates between what was submitted to the TCEQ 4 years ago and what the protestants expert set on the stand and testified to will naturally change. And I think that we have a case before us of another agency through a judicial proceeding misinterpreting what the TCEQ rules are. And I believe that those are the agency's rules to interpret and enforce and maintain. To tack on to what the ED testified to, of course, experts are going to differ in the side of costs. But when we filed the application, we don't have the benefit of hindsight, after years to evaluate and look at current construction cost, the price of steel, whatever it is, to poke holes in what the original petition was. And I think that that is, again, to put a burden on the staff, where do you end with the reevaluation? And this is a statute that's been in place for decades. The rules have been in place for decades, and there has not been a financial failure of a municipal utility district that I'm aware of. And if, cost at the end of the day will be what they are. We give our most reasonable estimate, and the protestants will make their overreaching estimate to try to deny the district if they are opposing
That's time.
it. And at that point, the risk is on the developer.
Thank you, Ms. Scott.
Thank you.
Colleagues, I feel like we're in a position where it's difficult to, or perhaps impossible for us to assess the cost, because what the petitioners have offered is conclusory. Really no evidence or analysis to back up the conclusory statement about their projected costs. I think Ms. Scott is correct in that the cost will be what the costs will be. We have competing estimates. What I'm looking for is a little bit more basis for the petitioner's assertion, and I don't find it. So I identify with OPIC's analysis. I think the ALJ's got it right. That's the big issue for me. Commissioner Janeka.
I'm largely in agreement. I think these issues, these questions have been raised about other matters, other facilities in our state, and we've acted and responded there. And I think in this matter, for me, the record really did bear out in the ALJ's analysis as in the order. Thank you.
Commissioner Gonzalez.
I'm also in agreement with your analysis on that, Chairman.
All right, colleagues, I found a few minor errors in the findings of fact that I would want to correct. And if you're amenable, I can read those into a motion and we can discuss on the other side. All right. Colleagues, I move that we adopt the ALJ's proposed order with the following changes. 1, amend finding of fact number 4 to replace the date December 11, 2022 with November 29, 2022 to accurately reflect the date that the notice of the petition was posted on the bulletin board in the Ellis County Clerk's Office. 2, amend finding of fact number 18 to replace the district's total construction cost to be $22,980,665.63 to accurately reflect the estimated cost included in the preliminary engineering report. 3, move finding of fact number 26 to finding of fact number 48A and replace the dollar amount of $2.25 with $2.64 to accurately reflect the total overlapping tax rate stated in the preliminary engineering report, and to include this finding in the appropriate section of the order relating to the effect on total tax assessments. And finally, 4, amend finding of fact number 28 to replace the dollar amount of $6.16 with $6.15 to accurately reflect the volumetric cost of the wastewater treatment rate. That is the end of my motion, and I realize that I read through that very quickly, so I'm happy to slow that down, but maybe I'll take a second if there is one, and then we can discuss.
I followed and I second the motion.
Is there any discussion? All right, you kept up with my speed reading. We have a motion and a second. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 4 is the consideration of the petition by Preston 56 LP for the creation of Preston Road Municipal Utility District of Grayson County. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Good morning again. It is one of those mornings, isn't it?
Yeah.
We are not going to hear from the ED's office or OPIC this morning, but we have their briefs. Colleagues, I agree with their analysis that the city of South Maid is entitled to a hearing. Commissioner Janeka.
I'm also in agreement on that point.
Commissioner Gonzalez.
Also in agreement.
I think we're ready for a motion.
I'll provide that motion and observe that with the small number of parties, referral to SOA or to our commission alternative dispute resolution program is appropriate. So I'll include that in the motion. I move that we grant the hearing request to the city of South Maid, refer the petition to SOA for a contested case hearing on the petition, and refer the matter to the commission's alternative dispute resolution program to run concurrently with SOA's scheduling process.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, we'll take the next item.
The next item is item number 5. And that is the consideration of gifts and donations of $500 or more in value given to the TCEQ and submitted for approval in accordance with Texas Government Code Chapter 575. And we'll begin with the executive director.
Is there someone? Oh, good morning, Ms. Tran.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Amy Mendez of the General Law Division representing the Executive Director. Before you are the gifts and donations received by the agency in the past 90 days. In accordance with Chapter 575 of the Government Code, the Executive Director has accepted these gifts and respectfully requests your acknowledgement of these gifts. I'm available to answer any questions you may have concerning these items.
Thank you, Ms. Mendez. Apologies. Ms. Smith, has anybody signed in to speak on this item?
No one is registered on this item.
Mr. Arthur, what says OPIC?
Good morning, Chairman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. Regarding item 5, OPIC supports approval of the resolution acknowledging acceptance of gifts and donations as presented by the ED.
Thank you, colleagues. I certainly appreciate the support of the agency's mission, and I am also ready to acknowledge acceptance.
Do you need a motion?
Sure.
Okay. I move that we approve issuance of a resolution with revised Exhibit A acknowledging the Executive Director's acceptance of the gifts and donations contained in the TCEQ Interoffice Memorandum to the Commissioners dated November 1st, 2024, docket number 2024-1525-MIS.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
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 Aye. The motion carries. Ms. Smith, please call the next items.
That takes us to the enforcement docket, which are items 6 through 35, and the executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Michael Parrish of the Enforcement Division, and with me today are Melissa Cordell, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 6 through 35. The total assessed administrative penalties are $1,077,552, with $111,048 deferred. $276,984 applied towards supplemental environmental projects, and $689,520 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Mr. Parrish. I have none. Any questions, colleagues?
No
Seeing
questions.
none. Do we have anybody signed in wishing to speak?
Nobody wishing to speak, but on items 6, 7, 8, and 16, we have folks available if the commission has any questions.
Thank you. Mr. Arthur.
OPIC has reviewed each of these enforcement items, and we support adoption of all the orders presented by ED staff.
Thank you, colleagues. I'm in the same place.
I move that we adopt items 6 through 35 as recommended today by the executive director.
Second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item 36 is the consideration of the monthly enforcement report, and the executive director's staff is here to present this matter.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me today are Michael Parrish of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2025 through September. There were 34 effective administrative orders issued, and of those, 4 contained supplemental environmental projects. These orders assessed a total of $377,013 with a payable amount of $272,816. $49,830 are to be paid towards supplemental environmental projects. 1,478 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 94 enforcement action referrals have been received. There are 3,076 pending administrative orders with 1,490 cases that are on the backlog. 135 cases are pending at the Attorney General's office for representation in district court, and no judgments have been issued. 1,335 cases are being tracked for compliance. We are available to answer any questions you may have.
Thank you, Ms. Cordell. Any questions, colleagues? Seeing none, Ms. Smith, has anybody signed in to speak?
No one is signed in on this one.
Mr. Arthur.
We have no comment except to say we appreciate staff's report.
Thank you. I do as well. Thank you, Ms. Cordell, and to your team. Colleagues, anything else? All right, no action is necessary on this item. So Ms. Smith, when you're ready, I'll ask you to please call item 37.
Item 37 is the consideration of petitions for rulemaking filed by the Texas section of the American Water Works Association and the Water Environment Association of Texas to amend 30 Texas Administrative Code, Chapter 30, to require water and wastewater operator licensees to complete ethics continuing education. The Texas section of the American Water Works Association and the Water Environment Association of Texas, as the petitioners, should present the matter, followed by other interested persons. And we currently have one person signed in, the ED, and then OPIC. We recommend limiting speakers to 5 minutes for their presentations, and petitioners may reserve time at the end as they bear the burden on their petitions. So with that, we'll begin with the petitioner. I believe we may have Nathan Vassar here.
Good morning, Mr. Vassar.
Good morning. It's good to see you all this morning. As was stated earlier, the petition for rulemaking is in front of the commission to commence discussions on an ethics requirement for water and wastewater operators. In sum, this is something that we think Texas can and should be a leader in doing on behalf of the environment, on behalf of the citizens of the state of Texas. Right now, operators for water and wastewater they have to have 30 hours of credits whenever they're up for renewal. What we're asking is that 4 of those 30 hours, and it's 30 hours over a 3-year cycle, would be driven toward ethics. We know that there are challenges with reporting. We see the enforcement dockets. We see the issues in other states. We see issues in Texas as well, when there are not ethical considerations that go into the important work that our water and wastewater operators perform. So as we have surveyed other states, what they're doing is we're surveying other groups such as engineers, lawyers. We're seeing that this is an area that probably could benefit from a requirement for ethics training. And so we're suggesting 4 hours as a initial placeholder. We think that's sufficient to at least provide enough detailed exposure to certain considerations that may come up before the water and wastewater operators. As mentioned, you don't have to look far to see issues on both water supply and water quality across the country, and we think this will be advantageous to the operators. We are looking forward to a robust stakeholder process, and in which we want to get the input of those who have an interest here. Again, we're not looking to increase the total hours for credits, but we're looking to, within that portion of 30 hours, do 4 hours there. So if there are any questions, we're happy to answer them. I think the materials lay out some of the background and what it is we're looking to do.
Thank you, Mr. Vassar. Colleagues, any questions for Mr. Vassar? Seeing none. Thank you.
Thank you.
And then we had Nicholas Cook signed in and as a virtual.
Mr. Cook, are you there? Mr. Cook?
Good morning, Commissioners.
We hear you loud and clear. Go ahead when you're ready, sir.
Thank you very much. My name is Nicholas Cook, and I'm a licensed water and wastewater operator. I'm here today to speak in opposition to this request of the Texas American Water Works Association and the Water Environment Association of Texas to require 4 hours of ethics training before the renewal of a license. In 2016, I joined the staff of the City of Deer Park as the supervisor of the surface water treatment plant. This facility is an 8 million gallon a day water plant, but also has a NELAC certified lab for the presence and absence testing of bacteria in the drinking water matrix. Part of the NELAC accreditation process includes ethics training that meets the standards produced by the accrediting body. The management and staff decided to make the ethics training mandatory for all employees of the plant, not just those involved in the laboratory activities associated with this accreditation. Fast forward to 2018. In October 2018, the city replaced its inline and benchtop turbidimeter to a laser-style turbidimeter. The new benchtop included storage of data. In January of 2019, a data audit found that 2 employees had falsified data in the 3 months of data that had been stored. TCQ was notified and an investigation took place. The environmental criminal investigator interviewed me and reviewed the data prior to interviewing the alleged offending operators. But over 140 samples that were reported in this monthly operating report were not in the audit and resulted in 3 months of violations for not reporting turbidities as required. The employees had their employment separated, 1 through termination, 1 through retirement. From the beginning of the investigation, staff was told that the license would not be stripped from these operators who falsified government records, as a quote from the investigator, occupational licensing does not prefer to remove the livelihood of people. When the case was getting ready to be presented to the grand jury in Harris County, COVID-19 interrupted life and it slipped through the cracks. While neither individual works for the City of Deer Park, both are still in the wastewater industry at other locations. The point of me opening this wound for myself and for the City of Deer Park is ethics training does not provide for ethically behaving operators. Enforcement of data collection and reporting with the threat of losing one's license would be a better deterrent. It's interesting to me that the 2 organizations that offer training would recommend training that they can sell or promote through their own organization as being free to members instead of providing an actual solution to unethical behavior that does occur in this industry. Engineers are required 1 hour of ethics training per year, but also self-report that training. That is not the ability of operators in the state of Texas, so the burden would be on the license holder or their employer to pay for training approved through the Occupational Licensing Division of TCQ or be ineligible for renewal if this becomes a rule. Please consider that ethics training did not prevent what happened in Deer Park, and it will not prevent what's going to happen in other facilities. If ethics training will not provide a more ethical industry, please ask yourself, is this the correct solution to employ? Thank you for the opportunity to speak today.
Thank you, Mr. Cook. We appreciate your comments and your perspective. I'd just like to offer this in response. I think you're talking about a related problem, and there might be more than one solution for a problem. Not to get ahead of us, but colleagues, where I'm going with this is I think we should consider this issue. But we're going to get to other speakers. I just want to respond to Mr. Cook's comments. And one thing that I want to say about self-reporting is that every environmental agency in the country, state, federal, local, relies on self-reporting. We cannot have a government employee looking over the shoulder of every employee of every regulated entity. We have to rely on each other to protect the environment. And that is an important duty and burden. And so when somebody falsifies records, that is more than a failure. That's a betrayal of the system that protects public health and the environment. We take that very seriously, and we seek support in criminal prosecution for folks who betray the system and who falsify government records. So, Mr. Cook, I'm sorry to hear that that prosecutions, for whatever reason, sound like they were not pursued in this case. I think that's unfortunate. I do think it's a separate issue, but I want to tell you that that we take that very seriously. I also suggested that I'm going to be in favor of a rulemaking process, just to tip my hand here, and I would invite you and hope that you would participate in that as a stakeholder. Do we have anybody else signed in to speak?
No,
Okay. Who's next?
the ED is next.
Good morning, Commissioners, General Counsel, and Public Entrance Counsel. On behalf of the Executive Director, I am Rebecca Morgan with the Occupational Licensing and Registration Division. With me is Haya Zeman with the Occupational Licensing and Registration Division and Alicia Ramirez with the Environmental Law Division. On September 25th, 2024, the TCEQ received a petition from the Water Environment Association of Texas, they're known as WEAT, and the Texas section of the American Water Works Association, known as TAWA. The petitioners requested that the Commission revise 30 Texas Administrative Code, Chapter 30, Occupational Licenses and Registrations, particularly sections 30.392 and 30.342, to require continuing education ethics training for renewals of all levels of public water system and wastewater operator licenses. The petitioners requested that 4 hours of ethics training be required in each renewal cycle, which is every 3 years. The proposed ethics trainings would count towards the 30 continuing education credits already required to renew a license. The Executive Director recommends initiating a rulemaking proceeding with stakeholder engagement to 1, evaluate stakeholder support for this proposed requirement, 2, determine how many hours of ethics training would be appropriate in each renewal cycle, 3, assess if there is enough interest from training providers to develop ethics training, and 4, evaluate if the ethics requirements should also be extended to other licenses beyond water and wastewater operators. The Executive Director believes that continuing education in ethics may be beneficial. These licenses play a critical role in ensuring clean drinking water and proper wastewater treatment and discharge. Other occupational licensing agencies, such as the Texas Board of Professional Engineers and Land Surveyors and the Texas Board of Professional Geoscientists, already require ethics training for each renewal cycle. Regarding timing for this petition, 30 TAC Chapter 30 is currently open for a rulemaking, which is anticipated to be finalized in February 2025. The Executive Director recommends initiating stakeholder involvement and, if warranted, reopening the rule after the legislative session is over so staff can incorporate any additional changes that may result from legislative action. An additional consideration is that the Executive Director would need to provide sufficient implementation time for the development of TCEQ-approved ethics training courses by multiple training providers. This would be to ensure multiple training options are available to licensed individuals before implementing any ethics requirement. Thank you, and we are available to answer any questions.
Thank you, Ms. Morgan. I have none. Colleagues, any questions? Seeing none. Ms. Jamison, good morning.
Good morning, Chairman, Commissioners, General Counsel, and Executive Directors, attorneys, and staff. For the record, I'm Jennifer Jamison on behalf of OPIC. OPIC has reviewed this petition for rulemaking and agrees with the ED's recommendation to initiate rulemaking proceedings with stakeholder engagement. OPIC specifically appreciates the ED's consideration of the fact that sufficient implication of this rulemaking may involve taking the time to develop TCEQ-approved ethics training courses by multiple training providers so that licensees have a variety of options when seeking to fulfill the requirement. Thank you, and I'm available for questions.
Thank you. Colleagues, any questions? Seeing none, thank you very much. All right. Well, you know where I'm leaning on this. This may be a good idea, so let's look into it. Just for the benefit of folks who may not understand exactly what a petition for rulemaking is, I want to make it clear that we're not granting a particular, we're not creating a rule. We're starting a process, just asking a question of whether there should be a rule. So no guarantee that we're going to get to a rule proposal, much less a final rule. We very well may. What I'm suggesting is we just begin the conversation, begin a stakeholder process. Commissioner Janeka.
Thank you, Chairman. I'm in agreement not to join you in piling onto our rulemaking process. I think there's also no promise on timelines, nor our staff's availability and bandwidth. If the Texas Miracle brings a new large stack of requests at our doorstep for our staff to address with some urgency, I don't know that, I hope stakeholders aren't getting any expectations about where we can based off past rulemakings, but I'm in favor of moving forward with it today.
Commissioner Gonzalez?
Also in favor of moving forward with it. I think that's an important distinction that you made, Chairman, with regard to the fact that this is not necessarily saying that we're going to come down in favor of the rules as proposed by the petition. I do find it a little troubling that we have to tell people that lying or misrepresenting on government documents is a problem. But I think these are issues worth exploring.
Thank you. And I hope that none of that was too discouraging for the petitioners, but Mr. Vassar, we're promising to spend some agency resources pursuing this. So that should be an encouraging note coming from an agency that's a little tight on resources. I think we're ready for a motion.
I'll happily make that. I move that we direct the executive director to initiate rulemaking to examine the issues raised in the petitions for rulemaking filed by the Texas section of the American Water Works Association and the Water Environment Association of Texas concerning amendments to 30 Texas Administrative Code, section 30.342 and 30.392.
A second.
The motion has been made and seconded. All those in favor say aye.
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 The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 38 is consideration of the adoption of amendments to 30 Texas Administrative Code Chapter 115 regarding the control of air pollution from volatile organic compounds. And the executive director's staff is here to present these items.
Good morning.
Good morning, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I'm Bob Gifford, the Air Quality Division. Joining me online is John Mentor with the Environmental Law Division. For your consideration today is item 38, the Executive Director's rulemaking to amend 30 Texas Administrative Code, Chapter 115, Control of Air Pollution from Volatile Organic Compounds. This proposed rulemaking would address the Federal Clean Air Act contingency measure requirements for the Dallas-Fort Worth and Houston, Galveston, Brazoria ozone non-attainment areas under the 2008 8-hour ozone standard. Staff respectfully recommends adoption of this rule revision. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. We're available to answer any questions.
Thank you, Mr. Gifford. I have none. Colleagues, any questions? Seeing none. Ms. Smith, has anybody signed in to speak?
No one has signed in on this item.
Thank you. What says OPIC?
Good morning, Commissioners, General Counsel, ED attorneys, and staff. For the record, I'm Josiah Mercer with OPIC. We have reviewed the rule proposal package and we support adoption of the proposed amendments to sections of 30 TAC Chapter 115. This rule amendment project is a federally mandated effort and it has potential benefits for the Dallas, Fort Worth, and Houston, Galveston, Brazoria communities, both in terms of reducing contingency VOC limits for these industrial adhesives and also in terms of helping to meet applicable ozone NAAQS. Public involvement plan and alternative language requirements were properly addressed. We attended the virtual public hearing that took place on July 25th, and we reviewed the comments that were submitted. We believe that the amendments are well drafted to achieve the intended emission reductions, and we appreciate staff's hard work on this project. We support adoption.
Thank you. Colleagues, for the reasons we've just heard, I support adoption as well.
I'm in agreement.
I'm also in agreement. I move that we adopt the amendments to 30 Texas Administrative Code, Chapter 115, as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call item 39.
Item 39 is the consideration of the adoption of the proposed amendments to 30 Texas Administrative Code, Chapter 230 regarding groundwater availability certification for platting. The Executive Director's staff is here to present this item.
Good morning.
Oh, it's not, okay.
Maybe start from the top, just to introduce yourself.
Sure,
again.
sure.
Thank you.
All right, good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Cindy Hooper. I'm with the Water Availability Division. With me today is Kim Nygren, also with Water Availability Division, and Kayla Murray with the Environmental Law Division. The rulemaking adoption before you will amend 30 TAC Chapter 230 related to groundwater availability certification for platting. The rulemaking will implement Senate Bill 2440 passed during the 88th Texas Legislature's regular session in 2023. SB 2440 amended the sections of the local government code that establish requirements for groundwater availability certification in the municipal and county plat application and approval process. The amended rule will make groundwater availability certification a mandatory component of the plat application and approval process. It also replaces applicability requirements with a reference to the applicability sections in the local government code. This change is to be consistent with the statute, which only charges TCEQ with establishing the form and content of a groundwater availability certification and with requiring specific information be submitted to the Texas Water Development Board and applicable groundwater conservation districts. The amended rule also removes the embedded forms and replaces them with references to TCEQ forms that can be updated as technology changes. The proposed rule was published in the May 24th, 2024 issue of the Texas Register. A public hearing was held on June 24th and the public comment period closed on June 25th. During the rule proposal, the Commission had specifically sought comments related to whether the term credible evidence from the statute should be defined in the rule. We received multiple comments on this issue and many asked that the rule define the term credible evidence. However, after further evaluating the statute language, the Executive Director concluded that TCEQ is not charged with defining applicability nor with defining the waiver requirements, and therefore we did not add a definition to the rule. The rule team also received many other comments ranging from substantive changes to clarifying language. The Executive Director did not make substantive changes because of the limited scope of this rulemaking, but where appropriate, made several non-substantive changes to the rule and to the forms. In conclusion, staff respectfully recommends adoption of these amendments to Chapter 230. Staff also requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you, and we're available for questions.
Thank you, Ms. Hooper. I have none. Any questions, colleagues? Seeing none. Ms. Smith, has anybody signed in to speak?
No one has signed in to speak on this item.
Mr. Martinez.
Good morning again, Chairman, Commissioners, General Counsel, and Executive Director.
Our office reviewed this rule amendment implementing Senate Bill 2440 by adopting rules in Chapter 230 that prescribe requirements for groundwater availability certification, which are needed to ensure consistency with the local government code and create benefits for the home buying members of the public who rely solely on groundwater by assuring that groundwater supplies will be available to them. Public participation was appropriately sought out, and several comments were received and integrated, including changes creating links to forms rather than utilizing embedded forms that may be updated or accessed differently as technology changes, as well as the inclusion of groundwater district contact information on the groundwater availability certification. Other comments were not integrated, such as the suggestion that the term credible evidence be defined by rule. We agree with the team's disposition of this comment, as applicability and waiver requirements are defined by statute, and the term credible evidence is already integrated in the waiver requirements language and defined by the local government code. Ultimately, we feel this rule package is in the public interest, and for the above reasons, we support adoption. Thank you. We're available for any questions.
Thank you, Mr. Martinez. I have none. Colleagues, any questions? All right. Acknowledging that some stakeholders had wanted more out of this rulemaking process, I think.
Can we pause for a moment?
Sure.
I think that I didn't have two people on my list, but I'm being told there are two people signed in to speak on this item.
I apologize.
So
Is there anybody in the room who wishes to speak on this item? Okay. Do we have names of people online?
I think virtually we have, we'll begin with Vanessa Puig-Williams with EDF.
Ms. Puig-Williams, are you there?
Yes, I'm here. Can y'all
We
hear
hear
me?
you. Yes.
Okay.
Please
Thank you.
just identify yourself again for the record, and then the floor is yours.
Sure. My name is Vanessa Puig-Williams. I'm a senior director with the Climate Resilient Water Systems team at Environmental Defense Fund. And thank you for the opportunity to comment. I just wanted to share a couple of thoughts, and first to thank the agency staff over the last few weeks for taking the time to meet with me as well as some other stakeholders like the Texas Alliance of Groundwater Conservation Districts for meeting with us to discuss this rulemaking. I think staff has done a really good job listening to all of the feedback, and while we're disappointed that those more substantive comments that were made on changes to the form and content of the groundwater availability certifications, we do hope that staff will consider reopening these rules at a later date to really look more closely at some of these comments, which really are about modernizing Chapter 230 and including more data, more state modeling from the Water Development Board in coordination with groundwater conservation districts, which will ultimately, I think, get at the intent of Senate Bill 2440, which was to ensure that these subdivisions and homes being built in rural parts of the state where there's limited water, limited groundwater, that we can ensure there will be water there in the future. So I look forward to continuing the discussion with staff, and wanted to thank them for being open to those conversations.
Thank you. Thank you for your comments.
And then we have Jennifer Badwar.
Ms. Badwar, are you there?
Hi, good morning. I didn't sign in to speak. I just signed in for attendance.
Okay.
Thank you. No comments.
All right. Well, thanks for joining us today. All right. Well, to continue the thought, I'm in favor of moving forward, colleagues.
I appreciate that. In my view, I think the intent of Senate Bill 2440 was to better ensure that new subdivisions have long-term groundwater available. And I think this is particularly important in rural areas when there's not a public water system serving the homes and they must rely on their household well. The groundwater availability certification process is meant to address concerns over groundwater availability for rural subdivisions, which is why Senator Perry's Senate Bill 2440 made it a requirement subject to the waiver process across the state instead of being discretionary. A large number of stakeholders' comments reflect a desire to update and modernize the form and content of the groundwater availability certifications so that they, for example, require developers to include more robust data to coordinate with groundwater conservation districts and to consider the Texas Water Development Board groundwater availability modeling. The rules have not been updated for over 20 years. Meanwhile, some stakeholders have suggested the groundwater data collection and modeling capabilities have improved, providing a more accurate picture of groundwater availability. I believe that the proposal to remove the embedded forms and replace those with references to TCQ forms provides a good step in allowing the format of the forms to be more efficiently updated as technology changes in the future. While I agree with the Executive Director's proposed response to comments that the requests for substantive certification content changes were outside of the proposed rulemaking scope as published in the initial proposal to implement Senate Bill 2440's changes, my recommendation based on stakeholder comments is that staff consider whether to update the form and content requirements of the groundwater availability certifications in Chapter 230 and/or Form TCQ 20982 via a separate future rulemaking or other action, including by communicating clearly to the legislature where we understand the metes and bounds of our authority on this issue to be. Thank you.
Thank you, Commissioner. Commissioner Gonzalez?
I'm ready to move forward with the rules as is. I think that they fit within the framework given to us by the legislature and within the legislation.
Thank you. I think we're ready for a motion.
I move that we adopt the proposed amendments to 30 Texas Administrative Code, Chapter 230, as recommended by the Executive Director for adoption.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
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 The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 40 is the consideration of the adoption of amendments to 30 Texas Administrative Code, Chapter 336, the radioactive substance rules, and the Executive Director's staff is here to present this item.
Good morning.
Okay, my name is Hans Wager. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Hans Wager with the Radioactive Material Division. Carolyn Catchings with the Environmental Law Division is available virtually. The adopted rulemaking corrects errors, removes obsolete text, adds clarity, adds a definition of closure to subchapter B of 30 TAC Chapter 336 radioactive substance fees, and modifies the training requirements for the radiation safety officer in 30 TAC 336.208A and 30 TAC 336.1215A5 to provide the Commission flexibility in determining adequate training for the radiation safety officer at different licensed facilities. The proposed rules were published in the June 28, 2024 issue of the Texas Register. A public hearing was offered on July 29, 2024. The public comment period closed on July 30, 2024. No comments were received and the proposed rules were not modified. Staff respectfully recommends adoption of this rulemaking to Chapter 336. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Mr. Wager. I have none. Colleagues, any questions? Seeing none, Ms. Smith, has anybody signed in to speak?
No one is registered for the item.
Thank you. Ms. Jamison, what does OPIC think?
Good morning again, Chairman, Commissioners, General Counsel, and Executive Directors, attorneys, and staff. I'm Jennifer Jameson on behalf of OPIC. OPIC has reviewed this rulemaking and respectfully recommends adoption of Chapter 336 Radioactive Substance Rules to ensure compatibility with federal regulations promulgated by the United States Nuclear Regulatory Commission. Thank you, and I am available for questions.
Thank you. I have none. Colleagues, any questions? Seeing none, I think the Executive Director and Office of Public Interest Counsel has laid this out pretty well. I'm ready to move forward.
I fully agree. And as a member of the staff of this agency who's formerly worked much more directly with that process, I'm very grateful for Dr. Whitaker's efforts and glad to support it and keep it moving along at a distance. I move that we adopt the amendments to 30 Texas Administrative Code Chapter 336, Radioactive Substance Rules, as recommended by the Executive Director.
Second the motion.
The motion has been made and seconded. All those in favor say aye.
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 The motion carries. Ms. Smith, when you're ready, please call the next items.
That takes us to items 41 through 44, which are the quadrennial rule reviews for 30 Texas Administrative Code, chapters 11, 12, 14, and 37. And the Executive Director's staff is here to present these items.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Gwen Rico with the General Law Division. Pending before you are items 41 through 44, the adopted rule reviews of 30 Texas Administrative Code chapters 11, contracts, 12, payment of fees, 14, grants, and 37, financial assurance. As required by Texas Government Code sections 2001.039, Executive Director staff conducted a rule review of these chapters to determine if the need for the rules within these chapters continue to exist. The proposed notices for these reviews were published in the July 26, 2024 issue of the Texas Register with 30-day comment periods. No comments were received for these rule reviews. Based on the reviews of these chapters, the Executive Director has determined that the reasons for the rules in chapters 11, 12, 14, and 37 continue to exist, and changes to the rules identified as part of this review process will be addressed in a separate rulemaking action in accordance with the Texas Administrative Procedure Act. In conclusion, we respectfully recommend approval of the adoption of the rule review of chapters 11, 12, 14, and 37. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. The project managers and staff attorneys assigned to these chapters are online to answer any questions.
Thank you, Ms. Rico. I have none. Any questions, colleagues? Seeing none. Has anyone signed in to speak?
No one has signed in.
Mr. Arthur.
For these quad reviews, OPIC considered three things. One, whether public comments were received. Two, whether any rules were found obsolete. And three, whether the rules are still needed. No public comments were received and no rules were found obsolete. The Chapter 11 rules are still needed to provide general procedures concerning contract operations, define procedures for vendors to protest procurement selections, and provide the procedures for resolving contract claims. The Chapter 12 rules are still needed to charge penalties and interest on delinquent fees, define the administration of charges on delinquent fees, ensure the agency receives fees owed in a timely manner, and provide the time frame, penalty, percentage, and interest rate charged on delinquent fees. The Chapter 14 rules are required under Texas Water Code Section 5.124, authority to award grants. Finally, the Chapter 37 rules are still needed to implement provisions of the Texas Water Code and the Texas Health and Safety Code, which require financial assurance and satisfy requirements of federal programs delegated from EPA. Therefore, OPIC agrees that the reasons for initially adopting the Chapter 11, 12, 14, and 37 rules continue to exist, and we support readoption of these rules.
Thank you, Mr. Arthur. I agree. Colleagues, I'm ready to readopt the rules.
I move that we adopt the rule reviews and readopt the rules in 30 Texas Administrative Code chapters 11, 12, 14, and 37 without amendment as recommended by the Executive Director.
Second the motion.
The motion has been made and seconded. All those in favor say aye.
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 Motion carries. Ms. Smith, when you're ready, please call the next items.
Items 45 through 48 are for closed session, and the commission will not be meeting in closed session today.
The time is 11:13 a.m. We are adjourned.